Sadly, Amy Barrett is not Antonin Scalia or anything close. She worked for Scalia, she's heavily praised him, but she doesn't believe in the same core values. Antonin Scalia believed that the 10th Amendment is what prevents the Supreme Court from legislating from the bench. I think the video that I include here shows that Amy Barrett doesn't even consider the 10th Amendment as any form of restriction, but rather takes the view that the judiciary can now make law from the bench and that it's now standard normal procedure. To Judge Barrett, the question is not whether the Supreme Court can make laws, but whether it creates laws based on tradition or creates laws more liberally adapted to today's issues. She clearly believes the time has passed where the 10th Amendment restricts the Supreme Court from legislating from the bench. In her long dissertation on the 14th Amendment's powers, she never once mentions the 10th Amendment. I'll first show a 2-minute clip of Antonin Scalia explaining the importance of the 10th Amendment. Next, you'll hear Amy Barrett describing how she feels the 14th Amendment should be used to legislate from the bench. She is clearly not cut from the same cloth as Antonin Scalia. She appears perfectly fine with legislating from the bench, and I think the second clip shows this to be true. I'll include a link to the full interview of Amy Barrett's, from which this is just a part. And I'd be very happy if someone could post a video of Amy Barrett saying that the Supreme Court should not legislate from the bench, or a video where she talks about the 10th Amendment protecting the public from the Supreme Court making their own laws. I really want to believe that Amy Barrett isn't the absolutely wrong candidate to represent those of us that believe the legislative branch should make laws and not the Supreme Court.
My view is, regardless of whether you think prohibiting abortion is good or whether you think prohibiting abortion is bad, regardless of how you come out on that, my only point is the Constitution does not say anything about it. It leaves it up to democratic choice. Some states prohibited it, some states didn't. What Roe versus Wade said was that no state can prohibit it. That is simply not in the Constitution. It was one of those many things, most things in the world, left to democratic choice. Basically because the theory that was expounded to impose that decision was a theory that does not make any sense, and that is, namely, the theory of substantive due process. There's a due process clause in the Constitution which says that no person shall be deprived of life, liberty, or property without due process. That is obviously a guarantee, not of life, not of liberty, not of property. You can be deprived of all of them, but not without due process. My court, in recent years, has invented what is called substantive due process by simply saying some liberties are so important that no process would suffice to take them away. And that was the theory used in Roe versus Wade, and it's a theory that is simply a lie. The world is divided into substance and procedure.
The due process clause of the 14th Amendment is, the relevant phrase here is pretty brief. It says, no one shall be deprived of life, liberty, or property without due process of law. And that it's from that phrase that we get this doctrine that Rick is referring to called substantive due process. The idea is that this phrase, this vague phrase, contains within it protection for certain substantive rights. So it is that portion of the due process clause that the court has relied upon in finding a right to abortion, for example. So in locating rights within that phrase, and the equal protection clause is also relevant here as well, that no state shall deny to anyone, any person, equal protection of the laws. The court, that is a particularly controversial area, that substantive due process area, because it is an area in which the court, in which the court says for itself what it thinks those rights are, based on what it thinks contemporary values are at the time. So Justice Scalia was not a fan of substantive due process because he felt like, listen, it says no one shall be deprived of life, liberty, or property without due process of law. That's a procedural guarantee about what happens to you before your property or your life is taken away, for example. That it doesn't contain a substantive guarantee saying that the state has to provide you certain guarantees, or the state through legislation can't do certain things. So on Obergefell, kind of this is the New York Times headline problem. I think as that case got reported, and as I heard my students even talk about it, even in law school, even after they'd become kind of acculturated to some of these things, people were presenting it as a vote on the court for or against same-sex marriage. But that's not what the opinion was about. What the opinion was about was who gets to decide whether we have same-sex marriage or not, with the majority saying that it was a right guaranteed by the Constitution, and so therefore states were not free, kind of in that Odysseus tying himself to the mast sense, that states weren't free to say that marriage had to be between a man and a woman. And the dissenters weren't taking a view. In fact, Chief Justice Roberts' dissent was very explicit about that. He said, those who want same-sex marriage, you have every right to lobby in state legislatures to make that happen. But the dissent's view was that it wasn't for the court to decide, that the Constitution didn't speak to the question, and so that it was a change that should occur through the legislative process. And indeed, many states were already moving in that direction and making legislative changes. So I think Obergefell and what we're talking about for the future of the court, it's really a who decides question. People often ask, and Rick and I talked about a little bit about this yesterday, well, in what cases might we expect to see this controversy of who decides? When would it matter? If Hillary Clinton wins, one example would be that the court, in a case when Chief Justice Rehnquist was the chief, decided that there was not a constitutional right to die. And it reached that decision. It was a substantive due process case, interpreting this phrase, no person shall be deprived of life, liberty, or property without due process of law. But the methodology that the court adopted there said, okay, we will recognize that there's maybe some substantive component to that guarantee. So we'll recognize something about substantive due process doctrine. But we will only recognize a right as one that's protected by the Constitution by substantive due process. I'm not talking about the First Amendment, Fourth Amendment, and all that. I'm just talking about the abstract rights that the court has found in that substantive due process doctrine. The court said, we will only find such a right if there has been a long tradition in America. See where the winds are blowing right now in society. We will look at American history and American traditions and say, yes, this is a right. For example, early substantive due process cases dealt with the right of parents to educate their children. That would be a right where the court could see, that sort of firmly rooted history. With the right to die, the court said there has been no long-standing tradition in America of protecting a right to die, and so we will not recognize that right. I could imagine that case coming out differently and that precedent being overruled if Hillary Clinton is president, because as we all know, there's a big push now, and I mean, we see this in other countries. We see it in Canada, we see it in different European countries. We've seen a big press for it in the United States, a press for a right to die. And I think that's going to be an issue when legislative change is slow, because people increasingly see the court as a political institution. When they can't accomplish things in the legislature, they try to litigate it and then declare a fast win through the court because they think it's faster to get it through the justices than to convince their citizens in the legislative process. So that's an example where the methodology of who decides would matter. If we're going to have assisted suicide, if we're going to have right to die, some states have already gone that route. The question is that something that people decide on a state-by-state basis, or does the Supreme Court impose a national rule that tells some states you're not free to make it illegal to commit suicide? The court has had an uneasy relationship with the death penalty for a long time. It came very close to holding the death penalty unconstitutional in the late 70s, early 80s, and then as the court came back, the states that wanted the death penalty really pushed back, and then the court retreated. I think there's a question of who decides there. Is that a state decision? Is that a constitutional decision? I think right to die. I think abortion. I think people phrase the abortion question when they think about the Supreme Court as, is Roe versus Wade going to be overruled? Roe versus Wade actually isn't the law. It was superseded by Casey versus Planned Parenthood. But we've had 30 plus years of a court that did take, on the whole, a more conservative approach to the judicial role, and Roe versus Wade, Casey versus Pennsylvania, left Roe largely intact, reinstated a new test, but it's still there. I don't think that abortion or the right to abortion would change.
Do you think some of the restrictions might change?
I think some of the restrictions would change. I think that's what we just saw last term in the case out of Texas. States, after the Kermit Gosnell affair and all of that, states have imposed regulations on abortion clinics, and I think the question is how much freedom the court is willing to let states have in regulating abortion. I think the question of, the court has held that in some circumstances, states can render partial birth abortion illegal, very late-term abortions. I think that's the kind of thing that would change. I don't think the core case, the Roe's core holding that women have a right to an abortion, I don't think that would change. But I think the question of whether people can get very late-term abortions, how many restrictions can be put on clinics, I think that would change. I think another area which people often overlook is statutory. Justice Scalia cared a lot about statutory interpretation, and this idea, similar to his idea, it was of a piece of his view of the Constitution, which is that when Congress enacts a statute, the words matter, you interpret the words as they're written, and if Congress made a mistake, I'm not talking about a scrivener's error, but if Congress didn't anticipate everything that would unfold, if the circumstances change, the judge doesn't have license to change the statute. That is a who decides question that it falls back to Congress. I think a lot of the cases that we're going to see coming to the court now involve statutory interpretation. The court just took up that transgender bathroom case from North Carolina. That's a statutory question. That's a question involving the interpretation of Title IX, which prohibits educational institutions that receive federal money, which almost all of them do from the Department of Education, from discriminating on the basis of sex. And the Department of Education and the Department of Justice interpreted that phrase in telling North Carolina in that case that it had to permit someone who is physiologically a boy but identifying as a girl to use the girl's bathroom. That is a huge shift, right? And this is why it's made the news. That would be a big shift, and it's a shift from the prior interpretations of that statute, which said separating locker rooms and showers and bathrooms on the basis of gender were okay. That's a big shift, and it's a who decides question, so that's pending on the court, and there are a lot of reasons why one might say that's a public policy debate. People will feel passionately on either side about whether physiological males who identify as females should be permitted in bathrooms, especially where there are young girls present, and we've seen all these debates. It's a who decides question. When Title IX was enacted, it's pretty clear that no one, including the Congress that enacted that statute, would have dreamed of that result at that time. Maybe things have changed so that we should change Title IX. Maybe those arguing in favor of this kind of transgender bathroom access are right. That's a public policy debate to have. But it does seem to strain the text of the statute to say that Title IX demands it. So is that the kind of thing that the court should interpret the statute to kind of update it, to pick sides in this public policy debate? Or should we go to our Congress, should we go to our legislatures and say, if this is the policy that we want to have now we have a new recognition of the rights of transgender people, and we want to shift the policy, is that kind of sea change the sort of thing that should come legislatively or from the court? And I think we're going to continue to see cases like that.